Welcome back. We're in conversation with Advocate Mkhwebane, who is president of the African Ombudsman and Mediation Association and, of course, public protector here in South Africa. So just to quickly go back to what we were talking about, you were speaking about some of the challenges that you perceive in the North Gauteng High Court. And I want to look at the system. So some of the criticism, and I know you spoke about various judgments and not necessarily this, but I mean, the criticism against you has been such that it's looked at what they've said is a flawed investigation, reprehensible behavior, and I spoke about contradictory agreements, apparently falling egregiously short of your duties, but also a number of falsehoods. So these are very serious allegations. Now, when we talk about that issue of transparency, when we talk about responsibility and trust in the Ombudsman, is that also measurable? Is it just a matter of opinion, or is a matter of one's public record in the work that they've done?
You know, the South African situation is different to the African situation. In South Africa, I think we focus a lot on the narratives. And again, this public protector who might not be the favorite of the certain class in South Africa. I mean, you know that the very same matters which were brought before court, the DA is one party which never supported the appointment of the public protector. CASAC, for instance, is one institution which is supposed to protect the constitutional democracy, but then you'd expect that institution to work hand in hand with the public protector. Therefore, if you are going to focus on this public protector, who is not doing all, I mean, we've done around 34,000 to 35,000 complaints since I joined the institution. And all that work is done by the investigators who are highly experienced. Out of those 35,000 investigations, I will only see the 102 reports, which are also investigated by the very same experienced team of investigators, who then brings to me what I normally see is your Section 7(9) notice, if people are implicated, because they've done all the investigation. When they bring the matter to me for signature is when I sign the provisional or the Section 7(9) notice, sending it to the other party to say, we've investigated, we've got this evidence, therefore can you respond to this evidence, give us your side of the story. And when they respond again, the very same team of investigators, they analyze the information, they finalize the report, which is brought in to the public protector to sign. And there's quality assurance. We've got legal services, which will also check the application of the law. Because normally when we investigate, we check what happened, what should have happened, what are the prescripts or the laws, the constitution, the various legal frameworks, the policies which are applicable to the facts. That's what we do. Come to the conclusion, and after that, we then come to the issue of the remedial action. So that's where the public protector is involved at the last stages of
Is it because of high-profile cases that you're contending that the people-centered approach, which is the mandate of the public protector, is not being focused on, it's not being highlighted on?
You know, we, again, 34,000 applications, and out of those, only 102 reports, which we can regard possibly as some of them. Actually, 5% of our work is your high profile or your complex matters. The rest is your bread and butter issues. Those we resolve through alternative dispute resolution, where we will call on the state, the government department. We then resolve the matter between them and the complainant, and the matter is resolved. So it's almost 95% which we resolve following that particular process. So it's only the few cases which we do. Again, some of them relates to this Executive Members Ethics Act, which the Public Protector South Africa is one of the few which is having that mandate compared to other African ombudsmen. Hence, I said to you, we've got different mandates because some of us, we will have this one
related. Is there at least consensus about what human rights and human dignity is within the context of, as you mentioned, Agenda 2063, some of the challenges that these African governments face?
Definitely. All of us are focusing on, especially the ombudsman, the rule of law, human respect for human rights, the issues of the good governance, issues of peace, because if we are mediating, for instance, if you have service delivery protests, for instance, in Sudan, that's how it started, with service delivery protests, but it led to what? Now to the removal of the sitting president. Then if you have an ombudsman who is involved also to bring the parties together to mediate, sometimes you wouldn't have a situation where there's violence or where in South African context, people burning the government infrastructure. So that's where we come in. All of us as ombudsman in Africa and South Africa, it's our core focus, especially helping into the aspirations of Agenda 2063.
So for your tenure specifically, what do you intend to be your focus?
My focus as the president of IOMA is that we would want to work very closely with the AU, especially to be recognized as the AU agency when it comes to mediation, because they do have a section which deals with conflict resolution, but we would want to support. For instance, if we deploy an envoy to South Sudan or even Lesotho, the president can appoint somebody to be there, but then if we've got an ombudsman there, that envoy can work with the ombudsman because they are independent, the public trusts that person, and when the envoy returns back to whatever country they come from, at least there is an ombudsman who will be doing that particular work. So our focus now for my term is to make sure that we work very closely with the AU, and that will also help us because we receive our funding through the Department of International Relations. If that's the case, then we will be included in the funding which they provide to the AU as South Africa to support issues relating to the African Renaissance, issues of peace and stability in Africa.
So let's talk about the general approach and principle of justice and access to it. Some have said traditionally you found that those who have money enjoy the benefits of that rather than those who are impoverished. Are you focusing on that, and how are you within the organization talking about improving that?
We do, because again our focus is on the people which are at the grassroots. Our services, all of us, are free. We are not charging, and in the South African perspective, you know, the Nkandla judgment where Chief Justice Mkhwebane said the public protector is like a biblical David, which the public is, where you defend or you are there to make sure that you assist the public to access the services because they cannot take the state to court. Africa-wise, it's like that. And what we normally do is that as an institution, for instance now, we will have to defend a lot of those matters which are brought before court. It's for the benefit of the very same complainants. I mean, we've got the vendor pension fund matter, which the finding is to benefit those pensioners. But then if your government is taking us on review, it's not about us, but it's about the very same pensioners to be able to be assisted by government. So our focus most of the time is to make sure that whoever is impacted or is prejudiced by the conduct of the state, then we come in as an institution to assist them.
Just a final question. Do you believe you're in the proverbial David versus Goliath fight, just in terms of your own personal career?
It's not personal career, but as the public protector, as
Yes.
an institution, that's what we are facing. Because, I mean, the public protector will go to even the raw state power to make sure that we protect the rights of the citizens or even everyone who is being prejudiced, we make sure that there's remedial action which will prevent the recurrence of that particular prejudice. But then if you find yourself, again, when you're saying those who have the resources fighting you, knowing very well that you don't have the resources or enough resources to fight. At the end of the day, you find that those who have resources then will have their way, because again, it depends on when they take you to court, which litigation is very expensive. Sometimes you'll find that instead of maybe opposing this matter, you'd rather abide, but that is an injustice to the people who have been prejudiced.
Public Protector, thank you so much for taking the time to speak to us. Advocate Busisiwe Mkhwebane is the Public Protector of South Africa, and she's, of course, the President of the Africa Ombudsman and Mediators Association. From us, that's it from African Perspective.